And Chair Meyer, we are all set.
Thank you and good morning. Agenda item, I'm Damian Meyer. I'm chairman of the Citizens Clean Elections Commission for this year. Agenda item number 1 is the call to order. It's 9:30 a.m. December 15, 2022, and I call this meeting of the Citizens Clean Elections Commission to order. I'd like to ask audience members to please keep their microphones on mute. And with that, we will take attendance. Commissioners, please identify yourselves for the record.
Kellen Payton.
Yeah, this is
Mark Kimball.
Okay, so we have Commissioner.
Steve Titler on the phone.
All right, we have Commissioner Titler, Commissioner Kimball, and Commissioner Payton all present. So item number 2 is discussion and possible action on meeting minutes for October 27 of 2022. Any discussion on the minutes from our October 27th meeting? If not, can I have a motion to approve the minutes?
Mr. Chairman,
Commissioner Kimball?
I move we approve the minutes for the October 27th, 2022 meeting.
Is there a second for that motion?
Second, Kellen Payton.
All right, we have a motion to approve the October 27, 2022 meeting minutes and a second. So we'll go ahead and call the roll. Commissioner Kimball?
Aye.
Commissioner Payton?
Aye.
Commissioner Titler?
Aye. Aye.
And this is Commissioner Meyer. I vote aye as well. Moving on to agenda item number 3 is discussion and possible action on the executive director's report. Tom?
Thank you, Mr. Chairman, members. This is our last meeting of the year, assuming, all the things being equal. So thank you all for being here. I wanted to take a little time here in the executive director's report to talk a little bit about where we are with the wrap up of the election in November. There was a canvass on December 5th, and we have during 2022 legislative session, the legislature changed the threshold and made it more, essentially saying that it was a recount would be required under a higher threshold than previously was there. So we have 3 state recounts, 2 statewide ones, and 1 in legislative district 13. Those are actually ongoing. That requires essentially a court order to start, and then a full set of logic and accuracy tests on those machines that are being used for tabulation, as well as a hand count audit. Unlike the general election, over the next few weeks, you won't be seeing sort of counties report out on a periodic basis as they complete the recount. Rather, the results of the recount will be provided to the court directly, and then unsealed in open court, and then the court at that point declares the results of the recount and the winner of the election. That said, we have a full resolution of the governor's race, the Secretary of State's race, and others. So inauguration ceremony is scheduled for January 5th. And then the first day of the legislative session, January 9th. We learned yesterday, Gina and I did an interview with an outgoing lawmaker and a government relations expert. They noted 2 things that are really interesting. One, we'll have divided government between the governor and the legislature for the first time in more than a decade. And something like 50% of the legislature is new to the legislature, which is a really extraordinary thing. And you can see there in the note that what we're working on, the voter education. Gina has been producing these subject matter expert videos, which we did for the beginning of the election season, and we'll doing those again. We filmed one with Gina as obviously a subject matter expert on post-election materials, post-election processes, including the recounts. And I think that was pretty well received. I know it got at least out to some reporters and folks. And we are working, Alec is working on, along with Reister and others, on analysis of our website. Because, I think our website has been it's a key tool for us, and I think for our outreach to voters because of its effectiveness. And so we want to keep that up. You can see that during this interim period, Avery has continued to do a number of different outreach activities. I think one he enjoyed a lot was the serving as a judge for the regional We the People competition, which was held at Corona del Sol, I believe last week. So I wanted to mention on candidates, as far as legislative clean general election candidates, I think we had at least 4 candidates at least in the legislature. I'm not sure we got higher than that. And then we had the 2 corporation commission candidates who were successful. And then we had, one other statewide clean elections candidate who was Superintendent Hoffman, who was not successful for re-election. I want to take real quickly, wanted to mention a few legal issues there. We did have an oral argument on November 15th in a case called Legacy Action Fund versus Clean Elections. That is a case that arises from a enforcement the commission undertook. If you can imagine this, before I think every member of the commission was appointed except for Commissioner, which is really hard to believe. It's a kind of bleak house quality. Anyways, the issue before the Supreme Court is whether or not if a defendant or a petitioner, rather in this case, fails to appeal an administrative order within the time allotted by statute, if they nevertheless can collaterally, that is to say, outside of the previous proceedings, get out from under that order by asserting that the administrative agency lacks subject matter jurisdiction over the object of the enforcement. So we was a 6-judge panel of the Supreme Court. Justice King recused herself. Justice Lopez also recused himself, but Justice Palander, former Justice Palander, sat in his stead. And so we'll have a result, hopefully, sometime next. We did wrap up and Mary's here, so thank you, Mary, for all of your assistance on this. We did wrap up the Clean Elections Commission versus Jennings with a permanent injunction barring the defendant in that case and her affiliates from using elections marks. I want to quickly mention that there are some they're post-election lawsuits. There's at least 3. I think there might be a 4th. Those are. I'm not sure what to say about them, in the sense that I don't. It's a difficult problem. They're particularly the challenge that arises out of the governor's race, because on the one hand, if you're, for example, reporting on that to the public as a reporter, you're going to follow the procedural aspects of that along, just like that's the story. This is what happened today. The judge set a briefing schedule. The judge set a hearing date. Those kind of things. The problem is, and this is a real issue, that those procedural steps that those of us who are either been attorneys or spent a lot of time with legal processes know are just what you have to do when someone files a lawsuit in order to regardless of the merits of the lawsuit, take on something like a meritorious kind of aspect by virtue of the fact they're being setting aside the AG litigation and to be amazed because of the recount, and so I just don't feel like I want to talk about that very much. The Lake versus Hobbs and the Fincham versus Fontes cases they're not plausible lawsuits. They're not going to result in anything remotely like what the plaintiffs in those cases are demanding. There's not a legal mechanism for that. There's not an evidentiary. And so I think, one of the things we'll continue to have to work on, and everybody who's involved in elections have to work on, is the fact that when you sue the folks who count ballots, you put those people in those folks in a position where they're having to defend their own work, right? That's an area in which there's it's a serious voter education problem, because the attention this lawsuit will get naturally by virtue of the proceedings that have to occur, whether it's meritorious or not, give it weight to which the pleadings in those two matters are simply not entitled. And so I think it's just something that we'll have to keep an eye on. I think that kind of wraps up my report. So if commissioners, if you have any questions for me or anybody else on staff, please fire away.
Commissioners, any questions for Tom on the executive director report? Tom, I had a question on the timing of the Lake Hobbs suit, or some of these suits. Don't they need to be heard within something like 15 days so they can be resolved before the inauguration?
Yeah, that's Chairman Meyer. Yes, that's correct. These are on a tight timeline. If they were to go to a hearing, for example, the judge has 5 days to resolve the case. They had to be filed within 5 days of the canvass. So these are fast-moving pieces of litigation. There's motions to dismiss in the Lake case and the Fincham case. The schedule for that's been set. I think the Fincham case is ahead on when they'll have a hearing. And then there'll be a hearing on the PI, on the motion to dismiss, I think on Monday in the Lake case. And the briefing will be completed over the weekend, right? So the motion to dismiss are due either today or tomorrow. The response is due on Saturday. The replies are due on Sunday. Hearings on Monday. It's there was a pretty good story in the Arizona Mirror website, which if I can circulate to you all if you want to read it up, with some legal experts assessing these cases. And one of the things that one of the lawyers and I tend to agree with this pointed out is that some of the way the allegations are made in the Lake matter are there would be simply no way to answer the complaint because of it's pled in such a sort of ham-fisted and illogical and actually incorrect manner. I mean, you'd be denying something in an answer, but you'd be denying something that, like, it's just like, I don't even know how you could formulate a response to it. It's so impossible.
Okay, any other questions? Thank you, Tom. Any other questions on the executive director's report? Okay, thank you. We're going to move on to agenda item number 4, which is discussion and possible action on overview of Proposition 211 from Campaign Legal Center Action. Proposition 211 was approved by voters and became effective with the official canvass on December 5th. According to the Act's text, the new law, known as the Voters' Right to Know Act, requires public disclosure of the identity of all donors who give more than $5,000 to fund campaign media spending in an election cycle and the source of those monies. The commission is charged with enforcement of this act, which sets minimum penalties, authorizes the commission to take complaints and to develop rules, among other things. Campaign Legal Action is a nationally known organization that works on campaign finance reform and election reform. They were deeply involved in the new act. So we have asked them to give us a brief overview of what they see as the key points of the act. So joining us are David Kolker and Elizabeth Shimmick, and I apologize if I mispronounced either of your names, please correct me. And they are both with the Campaign Legal Action. And David has spent 20 years with the Federal Election Commission before joining Campaign Legal in 2016. He has litigated important campaign finance cases such as Citizens United and Speech Now. Elizabeth served as chief staff in the Wisconsin legislature and has worked on a number of efforts to promote public engagement in the legislative process and against efforts to undermine democratic principles. She practiced political law before joining Campaign Legal Action. So with that, David and Elizabeth, thank you so much for joining us. You have our attention. And then once you've completed, we'll see if any of the commissioners have questions. So again, thank you so much. And the floor is yours, so to speak.
Well, thank you. First of all, thank you for inviting us on behalf of Jane and Beth. It's a pleasure to be with you. And yes, I have been involved with campaign issues, campaign finance issues since 1994. So I've seen the various cycles. So what we wanted to do this morning is to give you a brief overview and then take your questions, because I assume you'll have some, and if not today, sometime in the future as you dig further into it. We assume that you've been provided a memo that we wrote about Prop 211, as well as a frequently asked questions document that goes into quite a bit of detail. So with that, let me give you my half of the interview, and then I will turn it over to Beth. In our view, what the Act really does is restore campaign finance disclosure laws to what they were always supposed to be. When the Supreme Court upheld disclosure in 1976, and it has continued to uphold disclosure, just a footnote, in Citizens United, although we lost when I was at the FEC, the spending limit in that case, the court upheld disclosure 8-1. And what the court said in 1976 and has continued to say is that these disclosure laws provide voters with important information. And therefore, that's one of the main reasons they're constitutional. They help people evaluate the messages they hear. They help people evaluate the candidates who are running to know the money who's behind the candidates. They also help to prevent corruption, because if big money is exposed to the light of day, people will be less likely to engage in favors for campaign contributions. And finally, it helps the government, folks like you, enforce campaign finance laws if you have the data so that you can check whether people are abiding by the law. So the focus of Prop 211 is on big donors, those who give more than $5,000, and on the intermediary process where the money is just passed along from person to person. It does not limit expenditures. It does not limit contributions. We believe it's clearly constitutional. It goes back to why these laws were passed in the first place, and it is very narrowly tailored to prevent circumvention of disclosure requirements. The basic structure works like this. Lots of defined terms. It's a statute. If you are a covered person, you're somebody who spends more than $50,000 in Arizona on statewide campaigns or $25,000 on other campaigns, and you need to file reports about your spending, and you need to report the original source, the original monies that were used for campaign media spending. Campaign media spending is primarily focused on various kinds of public communications, ads that expressly advocate for or against candidates, that refer to a candidate in the window before the elections, that promote or attack candidates. It does cover ballot measure spending, so messages that promote or attack ballot measures are included. And it does include certain partisan voter activity. So if you do get out the vote drive, but you're only trying to drive, Republicans or Democrats to the polls, that is also included in the definition of the campaign media spending, as well as any underlying costs that were incurred to do that work. So if you have a TV commercial, it's not just that the money that you spend to get it on the air, but the money that you spent to produce the ad. If you're an individual and you're just spending your own money to advocate somebody's candidacy, or you're just contributing your own money to a covered person who's doing campaign electioneering, you don't really have to do anything under this act. It doesn't require you to report anything to the government. And the act does have a special provision to govern unions and membership organizations. The idea is that if somebody gives less than $5,000 in union dues, or if they're members of the Chamber of Commerce, that for the public, it's more important to know that that money is being spent by the union or the Chamber of Commerce and not to trace it back to the individual dues paying members. But it does have a $5,000 cap so that it's not used as subterfuge, so that an organization doesn't say, gee, everybody should pay $100,000 in dues and then we'll spend it in our name. So it would require tracing back if an organization is collecting more than $5,000. One of the key aspects of the act is the way it treats donors in terms of giving them notice and putting certain obligations on them. And this is because it does intend to trace back to the original source of the money. If you're a covered person and you're raising money for campaign media spending, when you go to donors to get money, if you want to use the money you receive for campaign spending, you need to let the donors know that you intend to spend the money that way in Arizona, and that donors have a right to opt out so that their money is not used that way. As the covered person, you don't need to have separate bank accounts, but you do need to keep track of who was opted in and who was opted out. It does give the covered persons a lot of flexibility in terms of timing. So for example, say you're an interest group and you're raising money in January, and you really don't expect to spend any money on campaigns. But come August, some horrible person is running and you want to try to defeat that person, you can go back to your donors then, the big ones, right? The ones who gave more than $5,000 and say, you gave us $20,000. We'd like to run a campaign against this person. I didn't notify you at the time that I wanted to use it that way. I'm notifying you now. You have a right to opt out. So that money can be collected in 1 month, but the notice could be provided later on, so that you don't have to, if you're an interest group, always tell people that you might use that money that way because maybe you don't know yet. If you are one of these big donors who give a covered person more than $5,000, and if you don't opt out, then the covered person is going to say to you, okay, are you the original source of this money, or did it come from somebody else? If you're an individual and you earned that money with your salary or whatever, or if you're a business and you earned that money selling whatever products you sell, you say, yes, I'm the original source of that money. But if you got the money from somebody else and you didn't earn it yourself, then you're not the original source, and you have to tell the covered person where that money came from and how it was passed along. So that if you're an interest group, say you're an interest group that got $100,000 from another interest group or from some rich person, you're not the original source. And when you pass money along to the covered person, you need to reveal who the original source is. Now, it does give donors quite a bit of flexibility, because the donor only has to tell the covered person the original source of the money being contributed, not all of the money in the donor's possession. So let me give you an example of that. Let's say you're an interest group and you've collected $100,000 in 4 $25,000 donations. So you have $100,000 in your treasury that is not original to you. You got it from 4 big donors to you. And you want to pass on $25,000 to a super PAC who's going to spend it on elections. The super PAC, when they get your $25,000 donation, is going to say, where did it come from? And you're going to have to say, well, it's not original to me. I got it from Kolker. And the first $25,000 that the interest group passes on, that group gets to decide, okay, I have $100,000. Whose money am I passing on? I don't have to reveal where all of the $100,000 that I've got in my account came from. I just have to reveal where the $25,000 that I'm passing on came from. And the interest group may say, you know, Kolker believes in this organization that I'm giving the money to. I'm going to tag the $25,000 I got from him as the original source of the contribution being donated to the super PAC. So that gives the donor a lot of flexibility. Some may argue too much flexibility. And I would just point out that if that interest group is sitting on $100,000, if it wants to give away all $100,000 to covered persons like super PACs, it will eventually have to reveal the original source of all 100,000. But if it's only giving away a subset of that money, say the first 25,000, it seems fair that they should get to choose among the funds that they have who is most appropriately tagged as the original source of that money. And we think that that doesn't create a dark money problem because, again, if all of the money that's given away, if all of the money that the interest group has is eventually given away, it will all eventually be revealed. And if it's not ever spent on campaign media spending, why should they have to reveal all of the money in their treasury? So that's one of the key ways that this act is very narrowly tailored. So I'm going to stop here and pass it over to Beth, who will talk more about your role in all this. And then we really hope you'll have questions and that we can try to answer them for you. And again, thank you for inviting us.
Thank you, David. Hard act to follow, but I have the privilege of discussing implementation of the Act and the new powers and responsibilities that the Act provides to the Commission. And you'll see in practice, some things won't necessarily change substantially after the Voters' Right to Know Act. For example, PACs who already do regular periodic reporting can largely stick with the schedule that's already been established and include this original source information within those reports. In other places, the Act provides the Commission with additional powers and responsibilities, primarily relating to these new traceback authorities. The Act is very specific about some of the Commission's powers and very general about many others. So I'll start by running through the 7 general powers that the Commission is provided with in the Voters' Right to Know Act. That's the ability to adopt and enforce rules, the ability to issue and enforce civil subpoenas, the ability to initiate enforcement actions and conduct fact-finding hearings and investigations, the ability to impose civil penalties for noncompliance, the ability to seek legal and equitable relief in court, and the ability to establish record-keeping requirements. So these are the general powers that are given to the Commission in the Act. The Act also includes some very specific powers for the Commission. And I'm going to highlight 4 key areas here. First and foremost, the Commission is required to establish top 3 original source donor disclaimer requirements for any public communications that are done by covered persons. These top 3 donors are those who directly or indirectly made the 3 largest contributions of original monies during a single election cycle to the covered person. In addition, the Act also requires the Commission to develop a means for this disclaimer information to be shared with an ad's audience, even if it's not technologically feasible to include all of that information on the face of the ad. For example, if I receive an ad via text or social media message, or if I see it in a little banner at the top of a web page, it might not be possible to fit all 3 personal names or organizational names of the 3 top original source donors on the face of that little tiny banner. The Commission is given the power to develop the means for that information to be shared with the audience, even if it's not directly on that ad in the immediate moment. And these top donor disclaimers are not new. They have been implemented successfully in other states and localities. This combines them with this original source traceback, and it gives that fuller picture of who the source of the funds are in the disclaimer instead of hiding behind, say, a series of vaguely named organizations. CLC has developed approaches to addressing top 3 donor disclosure, And we're happy to be a resource during the rulemaking process if the commission has questions. The next power I want to touch on is the commission's standing to defend the act on behalf of the state in the case of legal action, and the fact that the commission has the exclusive right to select counsel to represent the commission. And that's in regards to lawsuits that might arise as to the commission's duties under the chapter, or when it comes to challenges to the general validity of the law. The third specific power granted to the commission is the ability to adjust contribution and expenditure thresholds to reflect inflation. And this empowers the commission to keep the act current, relevant, up to date with inflation in Arizona without requiring additional legislation. The fourth and final power I want to touch on is the commission's ability to provide an exemption from original source disclosure for those original source donors who can demonstrate that they or their family members face a serious risk of physical harm if their identity were to be disclosed. And this is not a new concept. The Supreme Court has long provided for these protections for donors if they're facing a serious risk of harm. This provides the commission with the ability to grant that exemption directly, as opposed to forcing someone to sue in court in order to keep their identity secret in the case of that serious risk of harm. Those are kind of the four key specific powers provided. The final place I want to touch on in regards to implementing the act is a little bit different. It's the creation of a verified public complaint process. This allows any qualified Arizona voter to file a verified complaint with the commission, alleging that a person has failed to comply with the act. This is very similar to the citizen complaint process for the FEC under FECA at the federal level. If the commission were to dismiss a complaint or fails to take substantive enforcement action within a certain period, the complainant is empowered to bring a civil action against the commission in court to pursue the alleged failure to comply with the act. So in summary, as you implement the Voters' Right to Know Act, some things are not necessarily going to change substantially, particularly in terms of reporting for many PACs. The commission is granted a broad array of powers to implement and enforce the act, and a number of specific powers and responsibilities, including top 3 donor disclaimers. There's also the creation of this verified public complaint process, similar to the FEC. If David has any further thoughts to add, I'm happy to hand it back to him. Otherwise, we'd be happy to take any questions.
No, Beth, I have nothing to add on your half, so we're here to answer whatever questions you may have.
Thank you, David. I had a question on the the traceback process, and if the donor does the act give you the authority to actually get back to a human being as opposed to just a business? For example, like if it's an LLC, you know, in Arizona for an LLC, there's a statutory requirement that you have to disclose any member that owns 20% or more of that LLC. So like in this act, let's say if the original source of the funds is an LLC, we may not be able to know who, you may not know who those members are. I know in some states you have to disclose who any of those members are, like I believe in Delaware. Is there a way, does this act require it, does it allow you to get to the human beings that are part of that LLC or company, or are you just stuck with the entity?
I think that's something that you'll be able to focus on in implementation. I think the answer is yes, that you can. And here's why. If you look at the definition of original monies, it's either personal funds or business income. And business income is income, earned by an entity in its normal course of business. So if you have an LLC, I guess it depends upon what kind of LLC you have. If you have an LLC that is a genuine business and it's selling widgets, and they're literally using their profits from that and giving it to a covered person, then the LLC would be considered the donor, and that would be the end of it. But if the LLC is essentially a front group, where I've set up an LLC, I've fed it $3 million, and it really isn't much of a business, then the LLC isn't passing on money that it earned in the normal course of business. It's passing on money as a conduit. So I think it would depend upon whether the LLC is a bona fide business or not. So that if it's a bona fide business, I mean, this is something I think you'll have to decide as you interpret it. But my interpretation would be, if the LLC is a bona fide LLC and it's really earning money in the marketplace and that's the money it's giving, then that is the original source. But if it's being used as a front group, which is a common scheme in the dark money world we're living in, then you can pierce the veil and go back.
And then for Elizabeth, I had a question on the exemption of original source donors. I guess historically, how often or to what extent has that exemption been requested or implemented? And given the last 3-4 years in our political climate now in this country, is it being used more than it was previously?
I can speak to this to the best of my ability.
Sure.
David may have additional thoughts given his long history dealing with campaign finance law. While this is not a new exemption, it has been applied in some cases most prominently to the NAACP. That said, my understanding is it is not a commonly applied exemption. And I'm not personally aware of any recent uses of it, although given that it is meant to protect donors who might face a serious risk of harm, that may not be public information.
Let me jump in. It does, as Beth said, the original concept with the NAACP was actually not in the campaign finance context, but it is the first time the court recognized it back in a case in the 1950s. It has not been litigated very much. The Socialist Workers' Party brought a case that they won before the Supreme Court. And then over time, they went to this was at the federal level, they would go back to the Federal Election Commission every few years and say, we want to keep our exemption. And for years, the commission allowed them to. But I'm not exactly sure of the timing, maybe 10 years ago or so, the commission decided, the Socialist Workers' Party just isn't as vulnerable as they may have once been during, the 1950s. So that they don't have an exemption anymore. Most of the cases that have been brought about this have been rather weak, where people who are very wealthy have tried to say, my business is going to get harassed or whatever, and the courts just haven't really equated that with the NAACP, where you had individual people, being physically threatened or harmed. So the short answer is it hasn't been litigated much, and it's tended in recent years to be used as a sort of tool, frankly, for people who want to evade disclosure, who may not like being, trolled online, but don't really face the kind of serious harm equivalent to what the NAACP faced in the 1950s.
Thank you. Any other commissioners have questions?
Mr. Chairman, this is Commissioner Kimball.
Go ahead.
Elizabeth, I have a question for you. In your discussion of the powers that the commission is granted through this, you mentioned the amount that candidates get for running as a clean elections candidate. And is it my understanding that the commission now can adjust those amounts, the amount of funding a candidate who opts for clean elections funding receives?
I apologize. This applies to the contribution and expenditure thresholds that are discussed only in regards to the traceback, the original source traceback contained within the Voters' Right to Know Act. So there are thresholds that require reporting. That's, any contribution of more than $5,000 triggers that original source being named in a report.
Okay.
This provides the commission with the ability to adjust that amount as inflation changes the value of the money in that contribution.
Okay, I'm sorry, I misunderstood what you said then. Thank you. That's all, Mr. Chairman.
Thank you. Commissioner Payton, you have any questions?
I have a question, but it may be for Tom. Is this going to change our staffing? Do we have staff to follow this? And how does that really affect us? Set up.
Sure, Mr. Chairman, Commissioner Payton. So that's something we're looking at. We in the interim period before the canvas, we asked the Attorney General's office to appoint Mary O'Grady at Osborne Maladon to work with us on this, in addition to the other resources we have. That's sort of where we're starting. What we anticipate doing in the first quarter of next year is a process that involves, first assessing what the rulemaking needs to look like, kind of getting a handle on that first. There are some serious technological improvements that will be required of the Secretary of State's office. Those are similar to the technological improvements that have consistently been required of the Secretary's office for the last decade that they haven't undertaken. Those are the two first things. Third, on the staffing aspect of it, we're going to have to look at the volume of complaints. Our volume of complaints at the commission over the course of the last 10 years has dropped dramatically. I think in 2014, which was really prior to this act, the last time the commission and the Secretary's office together both were this was an active issue, it was a public issue, there were lots of complaints happening, and it was something that Secretary's office and we were working on a consistent basis. I think I'm going to end up overshooting. I think we had 30 or 40 complaints in the 2014 cycle. This year we've had 7, and that includes clean candidates. So it's going to take an assessment of where the money is being spent. That is to say, you were to look at the 2022 and 2020 election cycle. How many PACs that we know of are over the threshold? How many spenders who either filed trigger reports acquired already under the Elections Act or 6910 would have been at the state level? And then I think the other question that we get into is there's some local, that is to say, county and city races that will fall under this that would not have previously been on our radar. So I think that if we take a look at those inputs, we can start to make some decisions about that. We are not planning, frankly, on an immediate hiring sort of spree, if you will. We really look the way we see it, and obviously we're at the relative beginning of this, and the way we sort of understand the act and the intentions, and I'm open to be corrected on this by David or Elizabeth, but the key really becomes 2024. There are a number of implementation decisions on the rulemaking and technological side that need to be in place by 2024. There will be elections in 2023 that may or may not fall under the requirements of the act, and those we're going to have to sort of assess on an ongoing basis. So I'm sorry if that's kind of a long, incorrect answer, Commissioner Payton, but the answer is
Bureaucratic.
right. We have a process. We envision a process to get to the answer, and then when we get there, we'll be able to make some better recommendations.
But you don't sound intimidated by it. I guess is this going to be a daunting thing or not?
Well, my personal view is that with our staff and legal resources, Mary and Kara and Mike in particular, and myself, I mean, we have, had a lot of involvement in this issue in Arizona. And people can quibble about whether or not what we've done and what we propose. For example, we have one on the agenda, proposed resolution on a case. Those kinds of things. But we believe as staff that we have, and we think the regulated community believes this too, that the Clean Elections Commission has been the serious agency in the state with respect to the disclosure obligations that exist in state law and making sure at least those disclosure obligations are met. And so I am not particular. I'm not overconfident, but I am confident that with the some of the legal I hesitate to say even doubts, but legal clouds that have been put on some of the commission's existing express authority over independent spending cleared by this act, that we're in a position to implement it effectively. And I think, obviously, although all of you are in, holdover status, and we all hope at some point they'll begin a process of replacing commissioners, so long as you all are here and your experience with, a variety of different enforcement actions, litigation actions in this niche over the past decade. I feel like I'm hopeful that the voters knew, or at least had constructive knowledge, that the folks who would be, at least the current people who would be responsible for implementing this, would do an okay job of it.
Okay, then I have a question for our presenters. Do you foresee this cooling donations or not?
It's a little hard to say. I mean, I think there are people who give dark money who will give less if it has to come to light. But I think that there are a lot of people who give dark money, probably the majority, who will just say, okay, now I can't do it in the dark anymore. And I think that because there is some flexibility built into this act, as I mentioned, if you're sitting on a bunch of money and you're only giving away a subset of it to a covered person who has to do reporting, you can tailor the money that you have to be given to somebody who's going to disclose it in a way that is less likely to chill your donors. But I'm kind of speculating here. The people who, like us, who are for this kind of disclosure, we're sort of, it's not meant to chill spending or not. It's just meant to give the voters the information that they deserve. One thing to keep in mind, in 1976, when the Supreme Court upheld disclosure, they recognized that it might chill some donors. And they said, this is constitutional nevertheless, because it was so important that people have this information. So there could be some chilling. I don't believe that will matter in terms of defending the statute.
And are we the guinea pigs, or are we experimental, or how do you see that?
Yes and no. Alaska passed a ballot measure a couple years ago that does also involve tracing back to the true source. We have been involved in helping to defend the law there, and we won at the trial level, and now it's before the Ninth Circuit on appeal. Rhode Island recently successfully defended its top 3 donor disclaimer before the First Circuit Court of Appeals. So far these laws have been upheld. I would say that I think that the Voters' Right to Know Act is actually a bit easier to defend than the law in Alaska because it has the donor notice and opt-out provision, which the Alaska provision does not. So I think that will give Arizona a leg up on defending it. I don't doubt there will be challenges, but I'm quite optimistic that the courts will uphold it.
Thank you.
Thank you, Commissioner Payton. Any other commissioners have any questions for our guests? Okay, hearing none, I want to again thank David and Elizabeth for being with us today and providing the information. It's very helpful. Thank you so much, and we may take you up, like we will take you up on your offers to help in implementation. So we will probably be speaking with you again. So
okay. Well, again, thank you so much for inviting us, and our offer for additional question answering or assistance was genuine and heartfelt. So I hope this is just the beginning of our conversations.
Thank you.
Thank you. Thank you. Okay, so now we will move on to agenda item number 5, which is discussion and possible action on staff recommendation of conciliation agreement MUR 22-01 Freedom's Future Fund. This item relates to a matter that the commission made a reason to believe determination on in August. The staff is recommending conciliation agreement. That was in our materials. Tom, is there anything you'd like to add on this?
Mr. Chairman, just briefly, and I went almost an hour without a technological breakdown. The computer I'm working on.
Don't jinx it.
No, it just crashed. It literally just.
Okay.
I've got a message. I do not understand where my notes are supposed to be. So give me 1 second.
Gotcha.
Well,
the conciliation agreement looks like it's a settlement for a payment of $45,000.
Yes.
The monetary amount, and I assume has the Freedom, we'll say their name right, Freedom's Future Fund, have they agreed to this agreement? You're just kind of getting the blessing from us. Okay.
Yeah. So right. So just to walk through where we were, we anticipate that yes, we do believe that we will have their agreement, and that's why we're recommending it to you. We are recommending the $45,000 fine. They will also have to file reports with the filing officer that will encompass their spending on essentially on Kari Lake related ads. So ads that mentioned the clearly identified candidate of Kari Lake. Obviously, we are confident that that reporting plus the other provisions of the conciliation relating to ensuring that there was not some other relationship, for example, with another candidate, or otherwise an effort to evade the contribution limits. That's an important aspect of this as well. We also have an agreement from them not to do business in Arizona again, although I think they will wind up fairly quickly after this is completed. And then, on the fine, I mean, the issue is always, the new act sets forth some minimums that we don't have in current law, and that will be interesting there. One of the things that we have found in terms of when we negotiate fines are 2 specific things that, and I only bring it back to what we just talked about because these will be different things. First, the strongest place for us to stand in terms of effectiveness of the act is on the 941D reports. The fines on the 941D reports are only loosely proportional to the amount of the spending because they run on a daily basis. Second, when you go into a situation like this, especially where you have a corporation that in effect was created for this purpose, which will be a different, this will be a different standard going forward. You essentially, as soon as you go into the negotiation process, you're almost in a position of being a creditor, or more than anything else in terms of, so two problems. So that creates two problems. One, on the one hand, the fine schedule itself that's set up in statute is not driven by the amount of the spending. It largely, it's got literally a second order effect on the amount of the fines that cannot really at a certain point get to a level of a real beyond the cost of doing business type of number, right? And that's just sort of where things are. And then relatedly, the way that these organizations are currently set up, given the powers we know we have and we're most confident we have under the current regime, we really end up in this sort of creditor relationship at the end, rather than it's just the nature of it. Additionally, our focus has always been on trying to get the reports, trying to get the concession, trying to get the assurance that no other campaign finance laws are broken. So those are all the factors that go into this. We do think that this is on the order of the kind of fines that we have issued in similar cases. We did one with the teachers union in 2020 that was roughly proportional to this. So that's those are the factors that we considered, and we think that all those things taken together, and then adding, not only the risk of the organization essentially winding down in a way we might not be able to get to. In this case, they are in fact a Delaware LLC. We run into the litigation costs associated with the Legacy Foundation Action Fund case, where we're literally 8 years out, we still don't have the reports or the fine. So again, I think that all those things taken together, favor this recommendation, and we make it pretty unreservedly, but we did want to give you as much as we could our context for making the recommendation.
Any other questions for Tom on this conciliation agreement that he's recommending the commission approve today?
Mr. Chairman, this is Commissioner Kimball.
Go ahead, Commissioner.
Tom, I'm not sure I understood all of that. So you're saying basically that they're going to fold up shop anyway. So is this going to be collectible?
That's precisely the right question, Mr. Chairman, Commissioner Kimball. In order to ensure we can collect, we were willing to accept a smaller fine than we would have. What the existing act, one of the limitations of the existing act is it does create some incentives to essentially to go out of business rather than collect anything. So that gives leverage to the respondent, and we kind of think that so that's why I use the analogy of debtor creditor, because that's the kind of analysis that you get into when you're trying to make sure that you can collect enough to at least cover the effort put into bringing about the result of the report.
So Tom, yes, we're going to collect this 45,000.
Yeah, I'm sorry. Yes, I felt like there were two questions. One, what was I talking about? and two, but maybe I just didn't answer either of them.
Just to confirm, you probably said it, I just missed it. Commissioner Kimball, go ahead.
No, that's all. I wasn't clear how confident we are that we're actually going to see this money.
We're as confident as we can be.
Okay, thank you.
Chairman, you're muted.
I am sorry. Hearing no other questions from Commissioners Payton or Titla, is there a motion anyone would like to make regarding the conciliation agreement?
Mr. Chairman,
Go ahead, Mr. Kimball.
I move that we approve the conciliation agreement as outlined in our material today.
Thank you. Is there a second?
This is Commissioner Payton, I'll second it.
All right, we have a motion to approve the conciliation agreement attached to our materials. And we have a second to that motion. So we'll go ahead and vote on that motion and call the roll. Commissioner Kimball,
Aye.
Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
and Commissioner Meyer. I vote aye as well. Motion carries 4-0. The conciliation agreement is approved. So Tom, I assume you'll now move forward in getting this signed and performed?
Yes.
All right, thank you. That completes that item, correct? All right, thank you. Okay, item number 6 on the agenda, discussion and possible action on adoption of rule amendments to Arizona Administrative Code R2-20-211, R2-20-220, and R2-20-223 relating to compliance and enforcement procedures. A few months ago, we approved seeking public comment on some administrative rule changes intended to clarify some procedural steps in the event of investigatory and enforcement activity. We all have the rule language in our packet. We have not received any public comment, written public comment. Is there anyone here who would like to make comments before the commission discusses approval of these amendments? And again, that's directed to the public. Is there any member of the public who would like to make comment on any of the proposed changes to the administrative code? Okay. Do any of the commissioners have any questions or wish to further discuss these rules that we've already approved these, correct, Tom, and sent them out for comment? And
yes. So yes, you approved them for public comment.
Yeah.
We haven't received any. Just so you know, the next step will be we will submit these to the governor's regulatory review council.
Our friends at GER, yes. Okay, so any questions or discussion on this from my fellow commissioners? And if not, is there a motion?
Mr. Chair,
Yes, Commissioner Kimball.
I move we approve the proposed rule changes as outlined in our agenda material today.
Is there a second to that motion?
It's Commissioner Payton, I'll second it.
Excellent. We have a motion to approve the rule amendment set forth in our materials today. That motion has been seconded. I will now hold a vote on that motion. I will call the roll. Commissioner Kimball,
Aye.
Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
and Commissioner Meyer. I vote aye as well. Tom, any further comment on that? We send them to GERC and we'll hear back from them. Okay. Item number 7 is discussing and possible action on annual budgetary calculations and the 2023 spending plan. Every year, the commission considers a new calendar year budget. and we must approve certain calculations required by law. Again, this was item 7 in our materials. If you want to dig into those, get those in front of you here. And Mike Becker is available for any questions we have. So with that, I will turn it over to Mike, and then if there are any questions anyone has, now's the time.
Thank you, Mr. Chairman, Commissioners. I won't take too much of your time as you've all had the opportunity to review the numbers. A few areas I do want to point out in the 23 projections. Commissioner Payton, you'd asked about staffing regarding Prop 211 and issues like that. We do have the funds in the budget for that if it's necessary, if that's determined. So we are planning ahead for that just in case. Another area you'll see is rent charges. The move to our new office has increased our rent by about $21,000. So we do have that budget. It's higher than it has been in the past, but that's based on the new rent. And third, if you notice the revenue projections over the next 4 years, we are only projecting about $5.5 million to be coming in, which is a considerable drop from the $7 million, which you always projected in the past, and the $6 million projected last year. So wanted to bring that to your attention so that you're not surprised by that. We do, unfortunately, the numbers continue to drop in terms of the revenue we get from the court assessments. I think the biggest issue is the certain red light cameras, things like that we've had in the past that are no longer in existence, or that the ways around that. So just to make you aware, our revenue going forward is about $5.5 million from 23 through 26. And at this point, I don't see that increasing. Lastly, if you look at the actuals, those are not complete for 2022. They're only up through November, or only up through October, which means we still have November, December to come in. So once we do, I'll be able to give you more up-to-date and complete numbers of what we spent for the 2022 election cycle. But with that, those are the areas I really wanted to bring your attention. And with that, I'm happy to answer any questions.
Thank you, Mike. I had some questions on, I guess it's pages 10 and 11 of the PDF of exhibit item 7, and it relates to the fund balance where it shows us going, negative 14.6 million here in 2022. Could you explain that? Is that correct, or explain that to me? Tom, you look like you want to say something.
Well, I'm willing to. I mean, I'm only if it's a quirk of the law, so I'm just not. I don't know, Mike, if you want it, whoever, I don't care.
Sure. So, Mr. Chairman, Commissioners, what that is showing is where we began. The way the law is written, it forces us to look back several years and then project out a few years to 2023, provided we spend all the way to the cap. And because we don't receive, at best we were receiving $7 million a year. If we spend to the cap, we're always going to be in the red every time. So that's just to show what would happen if we went to the cap.
I think I'm remembering now that I maybe ask this question every year, so I apologize. But with that, maybe I'll be quiet and see if
That's a good question.
Commissioners have any questions.
I mean, what that really is if I may, Mr. Chairman, it's the delta between the revenue we once would have undertaken when we had a checkoff tax return that brought in about basically at this point, with the number of new taxpayers in Arizona, would be bringing in way more money than the court assessment. So That's essentially what that is the money the general fund currently has that should be in the Clean Elections Fund had the legislature not altered the funding formula significantly.
Page 12 is sort of with the projections is kind of a better number to look at, because you're actually viewing what we're going to actually spend, is not assume we're spending the whole thing, correct?
That's correct, Mr. Chairman.
Thank you. All right. Any other commissioners have any questions on this? No? Okay. So if not, can I get a motion to approve the memorandum in item 7 here regarding our budget?
Mr. Chairman,
Yes. Go ahead. Mr.
I move that we approve the proposed 2023 calendar year budget as outlined in our material today.
Is there a second?
It's Commissioner Payton, I'll second it.
All right, we have a motion to approve our 2023 calendar year budget, and it's been seconded. So we'll go ahead and vote, and I'll call the roll. Commissioner Kimball,
Aye.
Commissioner Payton,
Aye.
and Commissioner Titla.
Aye.
This is Commissioner Meyer. I vote aye as well. So the motion passes 4-0. Next, we have item number 8, which is public comment. This is a time for consideration of comments and suggestions from the public. Action taken as a result of public comment will be limited to directing staff to study the matter or rescheduling the matter for further consideration and decision at a later date, or responding to criticism. Please limit your comment to no more than 2 minutes. Does any member of the public wish to make comments at this time? You may also send comments to the commission by mail or email at ccec@azcleanelections.gov. So if you are out there and want to make a comment, go ahead and raise your hand. We'll recognize you. Okay. All right. Seeing there's no public comment, real quick, this is not on the agenda, Tom, so I'm not sure how much attention we can give it, but is there going to be a conversation about a couple things? We had the issue with the subpoena and Mr. Lasota. I'm assuming they didn't comply with that, and maybe we need to discuss that.
We'll be issuing you a notice relating to the steps we've taken on that in another correspondence.
And then the second is, I can't help but notice it's the last month of the year, and I'm the chairman. There's nothing in here about maybe next year's chairperson. Do we do that in January?
We can talk about. I think we can at least briefly say that will be on the next agenda, and we made a staff decision that we would rather not put that out in front of you. We just felt like it was.
No, that's fine. And then the other issue I wanted to bring up is this concept of commissioners rolling off petition, particularly if we're going to be implementing new things. I think we need to have a discussion on that. I should have talked to you offline about this, so I apologize.
No, well, and that is in the executive director's report. So, I guess if you want to clarify for the record, you want to go back up to item 3, just real quick.
Yeah, well, I guess let's circle back to item 3, the executive director's report. I apologize if I missed that, but
well, it's simply, and I'll just say, if I may, Mr. Chairman, we are, staff is in a kind of a weird place because of the nature of sort of self-interest, for lack of a way, or perceived self-interest. I believe that, we have at least internally and have tried to share where we can with folks who have a direct line to the appointing bodies, some recommendations we've received internally, and then we we believe that with the committee, the Voters' Right to Know Committee, Stop Dark Money Committee, has, an ongoing role under the act in terms of its defense of the new provisions of the Voters' Right to Know Act. So we think they'll be engaged. I think that creates a similar kind of a situation to what we once had with a group called the Arizona Advocacy Network that dissolved about a year or so ago. So there are some more contact points with the appointing executives than there might have been before. So I think that may come along. I think that one of the things, obviously, that everyone can be concerned about, should be concerned a little bit about, is we have, because of the timing of things, there's substantial experience that commissioners have, and I don't know if other commissioners want to speak to this specifically. Obviously, that's an issue too. What's the most effective way to do that while we're working through things and not losing every person who's been involved in, a lot of this stuff. I think what you'll find, for example, because we have gone through rulemaking, because we have gone through litigating the extent of a lot of how these disclosure laws work, a lot of that's going to come back to you. We haven't really dealt with it the last couple of years, but it's going to come back to you all in terms of that familiarity. So, those are all things that as staff members, we are trying to at least be as facilitative as we can toward getting that on the radar of the appointing body. The major, the other thing I'll just say is, and this is, I just want to be frank, the state government's going to go through about a 6 month to a year of real change. We have not had a change of party at this significant level since the 1950s, I think. So, I think so it's just one of those things where but I will say that the folks who are track the commission are, incredibly aware of the issue and very sensitive to it, and in many ways are in a position to be more, when Commissioner Payton was appointed, for example, there was an actual grassroots-ish, I don't know if grassroots is quite the right word. There was an organized effort by some folks who, I think the organization doesn't exist anymore, AZAN, to ask the governor to make an appointment. That was the last time that happened. So, again, but that may, those kinds of things can happen. And I think that we'll keep our eye on it. I'm just want to be, honest that, at the end of the day, there's a lot of things ahead of this in the queue for all of the different folks who are making decisions right now. And then a final point, two final points. One, the first is, obviously, I believe that the fact that there haven't been appointments made is actually a pretty strong indicator that, yes, it's not maybe the highest priority in the world, but I'm familiar enough with the current governor and the Secretary of State to say that if we were doing things that were really out of line or not orderly or not well administrated, they would take action. They have, and they will. So that's a vote of confidence. That doesn't change the train of your service, and I recognize that, but we do appreciate it, and we do think you're doing a very good job. The other thing is that, there's a provision in the act that says if any member resigns because they can't complete their term, whatever that means, in theory, there's a 30-day clock on the appointing person to make an appointment. That exists. Now, what I don't know is, whether or not that's a enforceable thing. In other words, I mean, you can put a clock on stuff and it just doesn't, it just doesn't happen. So, my hope is that over the course of the next month or so, maybe we'll hear more from some of the, organizations and the grassroots organizations, the real grassroots organizations that are involved in this, about what they intend to do. And if you want, commissioners, I'm happy to, have them communicate directly with you, because I think it is important that, that they have an understanding of what it is you do, what the job is, you know what I mean? There's a lot of aspects of this that, really may be important for stakeholders in this process, whether the regulated community or the advocacy community, to sort of get their arms around.
All right, well, thank you, Tom. Do any other commissioners? Oh, Ms. Carlson has her hand raised.
Yeah, sorry, Mr. Chairman, if I can, I know that Tom did do a little bit of record cleanup, but just to make it super crystal clear, since this took place started during the public comment, it was in his executive director's report on page 3 was where the appointment was identified. So I just want to make it really clear. Thank you.
Yes. Thank you for the clarification. Do any other commissioners have any questions or comments on that issue in item 3 that we revisited? Okay, if not, we'll move to, we'll jump back to agenda item number 9, which is a motion to adjourn. At this time, I would entertain a motion to adjourn from my fellow commissioners. Anyone?
Mr. Chairman, I would move we adjourn.
Thank you. Is there a second?
I will second that, Commissioner Payton.
All right. At this time, we have a motion to adjourn and a second. We'll call the roll for the vote. Commissioner Kimball,
Aye.
Commissioner Payton,
Aye.
Commissioner Titla,
Aye.
and Commissioner Meyer. I vote aye as well. So that ends our meeting. Happy holidays to everyone. Thank you for all your hard work all year. And if you're traveling or not traveling, just be safe and enjoy the season. So with that,